The verdict was the crime of 187 with a special finding of that being in the first degree, finding true. The court hereby sentences you to life without the possibility of parole. I will note, Madam Clerk, for our records, public safety and not being in the interest of justice. This court finds and sentences him to 25 years to life, and that will be consecutive. For count 2, a violation of 664-187, special finding of that being in the first degree by our jurors. Special finding also that was true. This court hereby sentences Mr. Serafini to life in prison. For the sentence for the finding, special finding under 1222.53D, that the jury found true, the court again understands that the court has discretion to strike this enhancement under H. Under 1385, this court declines again to stay, strike, or dismiss that enhancement due to the nature of the offense, a harm caused. Such a finding would endanger public safety and not be in the interest of justice. I make particular reference to Adrian Spore's statements about her mother and the pain and anguish that was caused from her being shot during the offense. The court has the discretion to run counts 1 and 2 concurrent and declines to do so, being that these are separate victims, considering the factors within 4.425. Therefore, count 1, finding of life without the possibility of parole, as well as 25 years to life for the firearm enhancement, shall be consecutive to count 2, which was the life sentence for the crime of 664-187, plus the enhancement of 25 years to life. That shall be fully consecutive. For count 3, violation of 459 first, a triad of 2, 4, and 6 years, the court finds a middle term and imposes a middle term. There had also been a special finding of a non-participant present at the time. For 1222.5A, the court also imposes a middle term of 4 years. That's a firearm enhancement for the first-degree burglary, accompanying that count. The special finding also being had by our jury under 1202.7C, the court imposes an additional term of 5 years for the great bodily injury done upon Gary, and also under 1222.7A, 3 years, and those are also imposed for the great bodily injury finding jury found against Wendy. The court understands as to those last 3 enhancements that the court has discretion to strike those enhancements. Under 1385A, this court declines to stay, strike, or dismiss those due to the nature of the offense, a harm caused, and that such finding again would endanger public safety and not be in the interest of justice. I have, in all of my findings on 1385, considered the defendant's lack of record and other mitigating factors set forth in the statements about him that have been submitted on his behalf. The court will, for count 3, as well as all the enhancements, all that term that I have imposed, which goes to 16 years, the court will impose, but stay that term under 654. There shall be no parole advisement, given that he is not eligible for parole. There is a request for this court to somehow dictate how he should be housed in prison. I'm not going to, it's not my jurisdiction to do that, and that would not be appropriate for me to weigh in on that at this point in time. Give me just one moment, please. This court will set a status conference, not a hearing yet, but Madam Clerk, a status conference. It'll be approximately in 2 weeks on a Monday in Department 32 at 8:30. So if you can pick us a date, not this Monday, I suppose, but next Monday, and it'll just be for a status if both counsel are available. What's that?
March 16th.
March 16th?
I'll be there.
All right, March 16th it is. That will be at 8:30 in Department 32 for status.
And I will submit firearms warrant when I get back to my office. If the court has one, well, I'll talk about it with the clerk. If we have one, we can just sign it here.
All right. If you can sign it here, great. So,
Otherwise, I'll go see you.
all right. Yeah, we need to clarify and take care of the firearms issue, and then discuss restitution and setting of a further hearing at the appropriate time for that issue. Mr. Serafini, you remanded to the custody of the sheriff to be delivered to Department of Corrections and Rehabilitation upon preparation of the abstract of judgment.
His appearance is waived.
It will be, he's to be transported to CDCR.
Let me just indicate for the record that I requested him to be present.
Yes.
For that.
Yes, absolutely. I would pre-authorize remote appearance to facilitate that. All right, thank you very much. Anything further from council?
No, thank you.
All right. All right, thank you. We are in recess.